for the next few minutes, we're going to chat about how over the last 4 years we've dealt with bad guys in Kansas and bad ideas out of Washington, because those are really two things that we have tried to focus on as your Attorney General. The U.S. Supreme Court entered a decision that we knew was going to have the effect of disabling one of our principal criminal sentencing laws, the so-called Hard 50 statute. The governor, the legislature responded to that, came back in a rare special session, did what everybody bemoaned couldn't be done, which was stayed on target, got their job done, and got out in record time. Thank you all for coming back in the off season to do that. It made a difference. We fixed the Kansas statute, but here's the more important thing, and here's why I'm talking about this 2 years later. That debate started a conversation about sort of the hierarchy of criminal sentencing in this state. And a majority in the legislature and the governor concluded this last year that, you know, it's nice that we have this Hard 50 sentence available for certain premeditated murders, but why isn't the penalty for every first-degree premeditated murder a Hard 50 sentence? Why shouldn't we be in a position that somebody who wants leniency from a court, if they've committed a first-degree premeditated homicide, have to go convince the court that they deserve something less, rather than the state, the public, the people having to convince the court that this person is so bad they deserve something more. And the legislature this past year became effective the first of this month, changed the default law in Kansas. The penalty for a first-degree premeditated homicide in this state now is 50 to life. It's a life sentence with a hard 50 before parole. And I think that is a dramatic change that will allow us to keep the worst of the worst killers off the street, in most cases for the rest of their natural life. That was prompted because we started that debate a year and a half ago. So again, thank you to our friends in the legislature and to Governor Brownback for making what I think will be a real difference long-term for safety in this state. You'll also hear us talking out on the stump about the work we've done in prosecuting child sex crimes around the state. I won't go into that in much depth over a pleasant lunch conversation here, but I will tell you this. We have been privileged on our watch to send more violent child molesters to prison for the rest of their natural lives than any prior Attorney General's administration in the history of this state. Sometimes an idea out of Washington is not just a bad idea, it's bad law. It's illegal. It is beyond the authority of the federal government to do what a majority in Washington has decided they want to do. Perhaps the best example recently was from this past month. The U.S. Supreme Court agreed on the principal issue with us and a group of other like-minded states on EPA's new greenhouse gas regulation. My view, our view at the AG's office is if the people of the United States want to incur the cost to regulate greenhouse gases, they should lobby their members of Congress to go forth and do those things. They should not go down to unelected people at the U.S. EPA and ask them to stretch a 1970s era statute in a way it was never intended to stretch in order to accomplish what they're afraid they can't get done politically. You can't run from the political fight and still, you know, get what you want. It's a have your cake and eat it too sort of approach that too many on the other side of the debate have adopted. So we've engaged on that. The greenhouse gas decision was a good one for us. We didn't get the entire regulatory scheme thrown out. I wish we had. We asked for it. I can't say I'm surprised we didn't get the whole thing thrown out. But we did get the court to clearly say that there is a boundary beyond which it will not allow EPA to stretch the Clean Air Act in order to regulate greenhouse gases. We were involved in the recent NLRB decision where the U.S. Supreme Court tossed out President Obama's nominees to the Labor Relations Board. Who knew when the Constitution said the Senate had to approve nominations, they really meant it? I mean, well, it's kind of hard to believe that the administration didn't read that provision quite right. We felt very good about that. At the end of the day, the Constitution is one of the great protectors of our liberty, and of course for a small state like Kansas, the power of the U.S. Senate is one of the great guarantors of our voice. And so anything that weakens the U.S. Senate's role in our overall national system of policy deliberation is not good for Kansas long term, and that's why we chose to engage in that, and we're very pleased with that outcome. And then the last thing I'll mention, and I'll close on this, you know, we talked a lot in 2010 about engaging in the fight with respect to Obamacare. We've done it. We're still doing it. We're not planning on stopping anytime soon. I've taken to describing where we are now as being 2 out of 3. We've won 2 out of 3. As you know, we did not win Chief Justice Roberts and therefore did not win our facial challenge, our frontal assault on the individual mandate the first time the case went up. We did, however, prevail in that same case on the spending clause issue, and Medicaid expansion is now a policy choice for states and for citizens rather than a mandate out of Washington, and I think that's something to be proud of. We now sort out the balance in Topeka, and our folks there will do the right thing, or voters in this room can decide they're not doing the right thing, but it's no longer imposed upon us.